Good morning, friends. In today's session, we will discuss about the liquidation PPIRP and voluntary liquidation process under the IBC. In our earlier session, we have discussed how the CIRP can be initiated by financial creditor or operational creditor or the corporate debtor itself. What happens when the initiation of the CIRP is initiated? Resolution applicants submit the resolution plan and the same is perused before the adjudicating authority for their approval. And if the adjudicating authority turns down that proposal, it means the proposal is not approved, then what recourse is available? The recourse available or provided under the IBC is to liquidate the company. That is the closure of the company. So the today's session will be focused on the liquidation, how the liquidation has to be done under the IBC. The liquidation process consists of Section 33 to Section 54 of the IBC. The related rules has also been mentioned, which has been prescribed in the Insolvency and Bankruptcy Board Liquidation Process Regulations 2016. Many a times we come across these words, default and not default. So the liquidation provisions under the IBC, which deals with the liquidation. So what is the meaning of the default? As we have earlier discussed, that the starting point of initiation of the CIRP is the default. Whenever the corporate debtor makes a default, then the right accrues on the part of the financial creditor or operational creditor and even the corporate applicant itself to initiate the CIRP. So default means where a corporate debtor has committed a default. If the CIRP fails and the corporate debtor enters into the liquidation phase. Now take the another aspect, that when there is no default, means the company has not defaulted, company is regularly paying the dues of the lenders or paying the due amount of to the operational creditors. It means the company is in a solvent position. So what will happen? Whether in that condition, means in the solvency condition, a company can be wound up. Yes, there is a provision under Section 59 of the IBC, which deals with the solvency liquidation. It means when there is no default. Liquidation versus winding up under the Companies Act. These are the two words which many a times are being used interchangeably. Section 2, Subsection 94A of the Companies Act 2013, which defines the winding up as the winding up under this Act or the liquidation under the IBC as applicable. Winding up as the concept was used in the Companies Act 56 and Companies Act 2013 also. When the IBC came into force in 2016, the Companies Act 2013 was amended to define winding up as also inclusive of a liquidation under the IBC. The concept of winding up is still covered in the Companies Act 2013. However, it is now limited to situations where the reasons for winding up are different from the reasons for which a CIRP can be initiated under the IBC. What it means, that the winding up proceedings cannot be initiated under the Companies Act 2013 for inability to pay or non-payment of debt or dues. The matter lies under the IBC itself. Now, what are the circumstances in which a company can be wound up by the tribunal, that is the Nclt, under the Companies Act 2013? So there are some 4 or 5 points which deals with the winding up under the Companies Act 2013. The company which have acted against the interest of the sovereignty, integrity, or security, etc. of India. Second point, on an application made by the registrar of companies, the Nclt is of the opinion that the affairs of the company have been conducted in a fraudulent manner, and also, if it is proper, that the company can be wound up. Next point is, the company has made a default in filing its financial statements or annual returns with the registrar of companies for the immediately preceding 5 consecutive financial years. And the Nclt is of the opinion that it is just and equitable that the company would be wound up. So these are certain parameters which are dealt with under the provisions of the Companies Act 2013. Now let us have a eye view of the liquidation provisions which are contained under the IBC. Section 33, that is the initiation of the liquidation, when it will be initiated, when the resolution plan is not approved by the Nclt. Then the adjudicating authority appoints the liquidator. Then what are the powers and duties of the liquidator that have been described under section 35? Then there is a concept of liquidation estate. Whatever the estate, the assets, the company, say corporate debtor, is having, that has to be transferred under the banner of liquidation estate. And the liquidator realizes the proceeds by selling of the assets and pay of the dues to the creditors. Then what are the powers of the liquidator to access information? Section 37, section 38, then consolidation of claims, verification of claims, admission or rejection of the claims, then determination of valuation of claims, appeal against the decision of the liquidator, preferential transactions and relevant time, orders in case of preferential transactions, then avoidance of undervalued transaction. There may be some transactions which have been undervalued that has to be, and that are described under section 45. Then what is the relevant period for avoidable transactions? Application by creditor in cases of undervalued transactions, orders in case of undervalued transactions, means what orders can be given by the Nclt, that has been described under section 48. Section 49, transactions defrauding creditors. Then extortionate credit transactions, orders of adjudicating authority in respect of this type of extortionate credit transactions. Then what is the position of the secured creditor in liquidation proceedings? And after all, when the liquidator has realized the assets, how the distribution of the assets will be made, and finally the dissolution of the corporate debtor. So this all from section 33 to section 54 of the IBC deals with the matter of liquidation. Let us discuss one by one of all these sections. Friends, if you have any of the query, you may write on the admin portal. I will continuously monitoring that admin portal and will try to address your queries as far as possible right now. So let us start for the section 33. That is the initiation of the liquidation. So where the adjudicating authority, before the expiry of the insolvency resolution process period. What is the insolvency resolution period? That is 180 days, or if any extension has been granted, up to 90 days, or the maximum period permitted for the completion of the CIRP or the fast track insolvency resolution process, whatever may be the condition, does not receive a resolution plan. It means when the adjudicating authority has not been given the resolution plan, in that case, secondly, the resolution plan has been reached to the adjudicating authority, but the adjudicating authority rejects that resolution plan. Then it may pass an order requiring the corporate debtor to be liquidated. When the order of liquidation is made by the adjudicating authority, a public announcement has to be issued stating that now and from onwards, the corporate debtor is in the position of liquidation. And the adjudicating authority may require such order to be sent to the authorities under which the corporate debtor is registered, means the ROC, the concerning official of the ROC. Subsection 2 of section 33, it describes that where the RP at any time during the CIRP but before the confirmation of the resolution plan intimates the adjudicating authority about the decision of the COC approved by not less than 66% of the voting share to liquidate the corporate debtor, the adjudicating authority shall pass a liquidation order. What we have discussed in subsection 1, that the adjudicating authority has the power, number 1, in case the proposal is not received. Number 2, in case the proposal is received but not accepted or not approved. In both that condition, the adjudicating authority may pass an order for liquidation. In this subsection 2, that describes that the resolution professional at any time during the course of CIRP, but before the confirmation of the resolution plan which has been received from the resolution applicant, the COC may decide. And how they will decide? By not less than 66% of the voting share. They may decide that this company should not survive or should not go on, and they may recommend to the adjudicating authority through the resolution process that the company should be liquidated. Order of the liquidation may be made by the adjudicating authority. The COC may take the decision to liquidate the corporate debtor any time after its constitution. It means that when the COC has been constituted, thereafter the COC is the supreme authority to take the decision whether the company may run or the company may be go for the liquidation. But before the confirmation of the resolution plan, including at any time before the preparation of the information memorandum. Now subsection 3 provides that where the resolution plan approved by the Nclt is contravened by the concerned debtor, means the plan has been approved by the Nclt, but the corporate debtor has not made the compliance, whatever the terms and conditions has been mentioned in the resolution plan, then any person means other than the corporate debtor whose interests are prejudicially affected by such contravention by the corporate debtor, that person may make an application to the adjudicating authority for liquidation order. So this is the third option. Subsection 4, it provides that on receipt of an application, if the Nclt determines that the corporate debtor, yes, he has contravened the provisions of the resolution plan, then it shall pass a liquidation order. Again, subsection 5 of section 33, it provides that subject to section 52, when a liquidation order has been passed, no suit or other legal proceedings shall be instituted by or against the corporate debtor, provided that a suit or other legal proceedings which may be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the Nclt. Subsection 6, it describes that provisions of subsection 5 shall not apply to legal proceedings in relation to such transactions as may be notified by the central government in consultation with whom? With the financial sector regulator. The order for liquidation under this section, means under section 33, shall be deemed to be a notice of discharge to the officers, employees, and workmen of the corporate debtor, except when the business of the corporate debtor is continued during the liquidation process by the liquidator. It means the moment the Nclt pass an order for liquidation, it will be presumed that it is a notice to all the employees or officers and workmen who are associated or working with the corporate debtor that their services has been or their duties have been discharged. They are relieved. Now there is a case on this section 33, subsection 7. The title is the Milind, Dixit and another. In this, the appellate tribunal held that when the corporate debtor is liquidated as a going concern, the liquidation order shall not operate as a notice of discharge to the corporate debtor's employees. So if it is not as a going concern, when the liquidation is not as a going concern, it will be deemed that the notice has been deemed to be received by the concerning employees, workmen. But when the corporate debtor is liquidated as a going concern, then the liquidation order shall not operate as a notice of discharge. The appellate authority further held that the adjudicating authority has erred in directing that the liquidation order should be deemed as a notice of discharge to the CD's officers, employees, and workers, as it conflicted the recommendation of the COC for liquidation of the corporate debtor as a going concern. Now, what will happen after the order of the liquidation has been passed under section 33 by the Nclt? That is section 34, which describes about the appointment of liquidator and simultaneously what will be the fees and who will pay the fee of the liquidator. So subsection 1 provides that where the Nclt passes an order for liquidation of the corporate debtor, the resolution professional appointed for the CIRP, means the initially when that person was appointed who was dealing with this CIRP process, shall be subject to the submission of the written consent by that RP to the Nclt, shall act as a liquidator. It means the same person, same resolution professional will be appointed as a liquidator, provided a written consent of that RP has been obtained and has been submitted to the Nclt. Then on appointment of the liquidator, all the powers of the board of directors, key managerial persons, and the partners of the corporate debtor, means in case of the LLP, shall cease to have effect and shall be vested in the liquidator. What we have discussed in the case of CARP, when the IRP is appointed by the adjudicating authority, the powers of the board of directors are suspended. But now in case of liquidation, as mentioned in subsection 2 of section 34, when the appointment of the liquidator is made by the Nclt, all the powers of the board of directors, key managerial personals, and the partners of the corporate debtor shall cease to have effect, and it shall be vested with the liquidator. Subsection 3, it provides that all the officials of the corporate debtor shall have to provide assistance and cooperate with the liquidator in discharging his duties. What are the duties? That the liquidator has to manage the affairs of the corporate debtor, and the provisions of section 19 shall apply in relation to the voluntary liquidation process as they apply in relation to the liquidation process, with the substitution of reference and the liquidator for the references to the IRP. So when the moment the liquidator is appointed, it is the duty of the officials of the corporate debtor to provide every type of assistance and cooperate with the liquidator. Subsection 4 of section 34, the adjudicating authority shall by order replace the RP if the resolution plan submitted by the RP was rejected for failure to meet the requirements, or the IBBI recommends the replacement of a resolution professional to the Nclt for the reasons to be recorded in writing, or the RP fails to submit the written consent. In above three conditions, the replacement can be made. And for the purpose of clause A and C of subsection 4, this one, A and C, the Nclt may direct the IBBI to propose the name of another IP to be appointed as a liquidator. When a reference is made by the adjudicating authority through the board, that is the IBBI, then IBBI shall propose the name of another IP along with the written consent from that IP within a time-bound manner, that is the 10 days of the direction issued by the Nclt. Then Nclt shall, on receipt of the proposal, the IBBI for the appointment of an IP as liquidator by an order appoint such IP as the liquidator. An IP proposed to be appointed as a liquidator shall charge such fees for the conduct of the liquidation proceedings and in such proportion to the value of the liquidation estate assets as may be specified by the IBBI. That has been prescribed under the liquidation regulations that has been framed by the IBBI. The fees for the conduct of this liquidation proceedings shall be paid to the liquidator from the proceeds of the liquidation estate under section 53. Now there is a case on this section 34. That is in the case of Punjab National Bank. It was opined that the lead bank in the COC, lead bank means when the consortium of lenders have made or arrange finance to the corporate debtor. So whosoever is leading, it's called the lead bank. Whose share of credit is much more, is called the lead bank. So the leader of the bank, lead bank in the COC challenged the appointment of the liquidator after the adjudicating authority passed the liquidation order. The appellate authority held that after a liquidation order is passed, the COC has no role to play, and they are simply claimants whose matters are to be determined by the liquidator and hence cannot move an application for removal. Now, what are the powers and duties of the liquidator? One question has been asked by one of the students that what is the difference between liquidation as a going concern and not as a going concern. So the Nclt may give the direction that liquidation has been ordered, but the company may run as a going concern till all its assets are disposed of and realized in a phased manner. That is called the going concern, and the liquidator has to run the company as a going concern. In another case, when it is not ordered as a going concern, the operation of the business transactions are altogether stopped, and whatever the assets the corporate debtor is having, that has to be disposed of, that has to be realized by the liquidator, and from that proceeds the creditors are to be paid. As you may know that when you are peddling the cycle runs. The moment you stop peddling the cycle, what will happen? Just after a few moments, you may fall down. So in case when the corporate debtor is altogether stopped, the persons dealing with the companies will altogether stop the transactions. Means when the company is not peddling the cycle, business cycle, all the credits, whatever the credits are coming from the debtors, that may be stopped, but the creditors may demand the payment. So it is better to give the order of liquidation as a going concern. So gradually the operation, the business operations of that corporate debtor will be slowed down as a going concern, and in that phased manner, the assets will be realized, and from that proceeds, the creditors will be paid off. I think I have clarified the query raised by Jay Srivastav. Now come on to section 35 that deals with the powers and duties of the liquidator. So what are the powers and duties? As we may know that the liquidator who has taken the charge of a company as a liquidator, he has to collect the claims from all the creditors. When the creditors are submitting, he has to verify whether the claims are genuine or not, whether the creditors have inflated their claims or whether their claims are genuine according to the transactions entered by the corporate debtor in its books of accounts. Liquidator has also to take into the custody of all the assets, property, and effects and actionable claim of the corporate debtor. Whatever the assets the corporate debtor is having, the liquidator has to evaluate that assets. And how it will be evaluated? that has been mentioned in the liquidation process regulations prescribed by the IBBI, that is the board, and shall have to prepare and report and has to be perused before the IBBI. The liquidator has to take such measures to protect and preserve the assets of the properties of the corporate debtor as he considers necessary. So as a prudent man, as a prudent person, treating that it is your own business and how you will manage that business. So as a prudent person, you have to dispose or take charge of the properties and dispose of the properties in a phased manner, as if treating that you are in a fiduciary position. And the liquidator has to carry on the business of the corporate debtor for its beneficial liquidation as he considers necessary. And the foremost task, for this task the liquidator has been appointed, that is selling of all the properties, whether it is movable, immovable, and of course the tangible or that type intangible properties, because the corporate debtor might be having some intellectual property rights like copyright, trademarks, etc. So the liquidator has to dispose of that property in a phased manner and has to realize the assets in order to make the payment to the creditors. Section 35 further elaborates that liquidator has to draw, accept, make and endorse any negotiable instruments, including the bills of exchange, hundi, promissory notes, like that, to take out in his official name, not in his personal name, but in his official name, the letter of administration to any deceased contributory, and to do in his official name any other act necessary for obtaining payment of any money due and payable from a contributory or his estate, which cannot be ordinarily done in the name of the corporate debtor. And in all such cases, the money due and payable shall, for the purpose of enabling the liquidator to take out the letter of administration or recover the money, be deemed to be due to the liquidator himself. To obtain any professional assistance from any person or appointment any professional in discharge of his duties, obligations and responsibilities, and to invite and settle claims of the creditors and claimants and distribute proceeds in accordance with the provisions of the IBC. Section 35 further elaborates that the liquidator has the power to institute or defend any suit, prosecution or other legal proceedings, whether it may be a civil or criminal, in the name and on behalf of the corporate debtor. He has to investigate the financial affairs of the corporate debtor to determine undervalued or preferential transactions, to take all such actions, steps, or to sign, execute, and verify any paper, deed, receipt documents, applications, petitions, affidavit, bond, or instruments, and for such purpose to use the common seal, if any, as may be necessary for the liquidation, distribution of assets, and in discharge of his duties, and may be necessary for the liquidation of the corporate debtor, and to report the progress of the liquidation process in any manner as specified by the board, and to perform such other functions as may be specified by the board, that is IBBI, and to consult any of the stakeholders entitled to a distribution of proceeds under Section 53. So Section 35 describes about the powers and duties of the liquidator, right from the taking possession of the assets, collect the claims of the creditors, to do the business in the official name of the corporate debtor. It means ABC company within bracket under liquidation. Maintain a separate account in the name of the company titled as ABC within bracket under liquidation. And whatever the proceeds are being realized by selling of the assets of the corporate debtor, that amount has to be credited through that bank account which are being maintained for that specific purpose. And out of the proceeds, he has to make the payments toward the creditors. Now let us have a case law on this, section 35. In Rajiv Kaul versus Vinod Kumar Kothari, the appellate authority held that liquidator has the power to remove the nominee directors of the corporate debtor on the board of another company. So the liquidator has power that whosoever is having the position as a nominee director, he can remove that. In another case, a group of unknown persons made threats with weapons and did not allow the liquidator to enter into the premises of the corporate debtor to carry out his functions. What recourse is available before the liquidator? The liquidator may make a reference to the adjudicating authority, and in this case, the adjudicating authority directed the superintendent of the police to give adequate police protection to the liquidator to enable him to perform his duty. Now, section 36, which deals with the liquidation estate. For the purposes of the liquidation, the liquidator shall form an estate of assets, which will be called the liquidation estate in relation to the corporate debtor. And the liquidator shall hold the liquidation estate as a fiduciary for the benefit of all the creditors. What is the liquidation estate? But whatever the assets the corporate debtor is having in its own name, which are being reflected in the balance sheet of the corporate debtor, whether it may be the movable assets or immovable assets or intangible assets in the form of IPR, that has to be put in the liquidation estate. It means these are the estates, these are the liquidation estates which the liquidator is supposed to realize the proceeds by selling of these assets and for the payment of the creditors in a fair manner. The liquidation estate shall comprise all the liquidation estate assets, which shall include the following. But we have discussed that assets over which the corporate debtor has ownership rights, number one. Secondly, the assets may or may not be in the possession of the corporate debtor, because the ownership might be lying with the corporate debtor, but the physical possession of that assets may be in the hands of some other person. For example, the corporate debtor has given some machinery for repairing, and that machinery is lying with that another person to carry out the work of repairing. It means the ownership is with the corporate debtor, but right now, when the liquidation order was passed by the adjudicating authority, that asset was actually not in physical possession of the corporate debtor, but the corporate debtor has the ownership. So in liquidation estate, whatever the assets, the corporate debtor has the ownership over the assets, that has to be included in the liquidation estate. Then tangible assets, whether movable or immovable, intangible assets, but we have mentioned that intangible assets may be in the form of the IPRs, maybe in the form of the securities, including shares held in the subsidiary of the corporate debtor, financial instruments, any insurance policy, contractual rights like that. And the assets subject to determination of ownership by the court or any authority. Any assets or their value recovered through the proceedings for avoidance of the transactions. What is the avoidance of the transaction? That we will discuss in our succeeding slides. And any asset of the corporate debtor in respect of which a secured creditor has relinquished security interest, that has also to be included in the liquidation state. And any other property belonging to or vested in the corporate debtor at the insolvency commencement date. All proceeds of the liquidation as and when they are listed. Then what is not included? We have discussed right from subsection 1 to section 3 that these are the assets which are to be included in the liquidation state. Subsection 4 describes the assets which are not to be included in the liquidation state. But they are that the assets owned by a third party, but which are in actual possession of the corporate debtor. As I have given an example that corporate debtor has parted the machinery for repairing. Similarly, the corporate debtor may be engaged in the business of repairing work, and some other person who have the ownership of that machinery has delivered the possession of that assets with the corporate debtor for doing some repairing work. That in this case, the corporate debtor is not having the ownership, but actually it is in the possession of that machinery. So subsection 4 describes that type of assets on which the corporate debtor is not having the ownership, that has to be excluded from the liquidation state. Some of the points has been mentioned in subsection 4 subclass A, that is the assets held in trust for any third party, bailment contracts, all sums due to any workman or employee from the provident fund, pension fund, and the gratuity fund. These are the liabilities. And the contractual arrangements which do not stipulate transfer of title but only use of the assets. There may be some assets on which there is no transfer of the ownership. You can simply use that assets. That has to be excluded. And such other assets as may be notified by the central government in consultation with the financial sector regulator. Subclass B, it provides that the assets and security collateral held by the financial service providers and are subject to netting and set off in the multilateral trading or clearing transactions. Now there is a case law on this, section 36, subsection 4, subclass A. State Bank of India versus Moser Beer. In this, the Supreme Court held that issue arose as to whether the amount due to workmen of the corporate debtor in liquidation towards their provident fund. So the adjudicating authority held in this case that the provident fund dues, pension fund dues, gratuity dues cannot be the part of the estate as per section 53. The financial creditor filed an appeal against the order of the adjudicating authority. What happened in this case? That the company was having in its possession some of the dues which are to be payable to the workmen or employees towards the provident fund, gratuity, etc. And the financial creditor claimed that these are the assets the corporate debtor is having, but the adjudicating denied for inclusion of these funds in the liquidation state assets. The Nclt examined the meaning of what is the meaning of the liquidation state under section 36, and it opined that all sums due to any workmen or employees from this provident fund, pension fund, gratuity fund should not be included in the liquidation state assets and could not be used for recovery in the liquidation state. These are actually the ownership right on the part of the employees or the workmen whose provident funds are lying with the company. Since they do not form part of the liquidation estate assets of the corporate debtor, the question of distribution of the provident fund, pension fund, or gratuity fund does not arise at all. Subsection 4 further lists out the assets which are not to be included in the liquidation estate assets, that is the personal assets of any shareholder or partner, assets of any Indian or foreign subsidiary of the corporate debtor, and any other assets as may be specified by the IBPI. Now, section 37, which deals with the power of liquidator to access information. Since the liquidator has to discharge his duties, the liquidator has every right to have in its possession certain information. What this type of informations are? The wording starts from these words, that notwithstanding anything contained in any other law for the time being in force, the liquidator shall have the power to access any information system for the purpose of admission and proof of claims and identification of the liquidation estate assets relating to the corporate debtor from the following sources. What are these sources? From any information utility, any credit information system regulated under any law, any agency of central, state, or local government, including the registration authority. If any of the information, the liquidator can take out that information, he has every right to take that information from these type of service providers. Then information systems for the financial and non-financial liabilities regulated under any law for the time being in force. Information systems for the securities and assets posted as security interests regulated under any law for the time being in force. And any database maintained by the IBPI and any other source as may be specified by the board. Subsection 2 of section 37, it provides that the creditors may require the liquidator to provide them any financial information relating to the corporate debtor in such manner as may be specified. So the creditors who have made a claim before the liquidator may require some information from the liquidator, and if the liquidator has received any such type of requisition from the creditors, then the liquidator shall provide that type of information to such creditors, and the time limit has also been prescribed, that is within the period of 7 days from such request. And if that person is not providing the information, the reasons has to be mentioned for not providing such information. Liquidator shall receive and collect the claims of the creditors within a period of 30 days from the date of commencement of the liquidation process. Liquidation process, when it starts? When the order of the adjudicating authority has been made. From that date to within a period of 30 days, the liquidator has to receive and collect all the claims from the creditors. Now, the financial creditor may submit a claim to the liquidator by providing a record of such claims with an information utility. The provision to this subsection describes that the information relating to the claim, where it is not recorded with the information utility, the financial creditor may submit the claim in the same manner as provided for submission of claims for the operational creditors. So the Financial creditor may submit the claim. Similarly, operational creditor may also submit the claim. And when a person is having a dual status, means he is partly a financial creditor and partly operational creditor, then in that case, the manner of submitting the claim to the extent the financial debt is owed on the part of the financial creditor, and partly when he is termed as a operational creditor, then that claim has to be submitted as prescribed under subsection 3 of section 38. After submission of the claim, if the creditor wishes to withdraw the claim, it may do so within 14 days of such submission. After submission of the claims, the duty on the part of the liquidator is to verify all the claims and submit the information as specified by the IBBI. Liquidator may require any creditor or corporate debtor or any person to produce any other document or evidence which he thinks necessary for the purpose of verifying the whole or any part of the claim. Now, after receiving the claims, the liquidator has to decide whether the claims are to be acceptable or these claims are to be rejected. So the liquidator has to decide whether to admit or whether to reject, whether to admit the claim in whole or whether to admit the claim in part. So both the options are available with the liquidator. And if the liquidator is declining or rejecting any claim, he should record in writing why he has rejected the claim. And after admission or rejection of the claim, the liquidator shall inform the concerned creditor and the corporate debtor within 7 days of such admission or rejection. 41 Section 41 of IBC, this describes that liquidator shall determine the value of the claims admitted in such manner as may be specified by the IBBI, that is under the liquidation regulations. Section 42 deals with the appeal against the decision of the liquidator. In case the liquidator has rejected any claim submitted by the financial creditor or operational creditor, what records is available before that creditor, he may make an appeal before the adjudicating authority that the liquidator has denied the acceptance or admission of my claim. So the right is available with the creditors. And that is also prescribed. There is also a prescribed time limit, that is within 14 days of the receipt of the decision, the Nclt, a creditor may appeal to the Nclt against the decision of the liquidator, either admitting or rejecting the claim within 14 days of the receipt of such decision. Now the preferential transactions and the relevant time, where the liquidator or the RP is of the opinion that the corporate debtor has at relevant time given a preference in such transaction to any person, he shall apply to the Nclt for avoidance of such preferential transaction. Corporate debtor shall be deemed to given a preference if there is a transfer of property or an interest thereof of the corporate debtor for the benefit of a creditor or a surety or a guarantor for or on account of an antecedent financial debt or operational debt or other liabilities owed by the corporate debtor. And the transfer has the effect of putting such creditor or a surety or a guarantor in a beneficial position that it would have been in the event of distribution of the assets. So these preferential transactions are relevant. Preferential transaction shall not include the following transfers. Means when the transfer has been made in the ordinary course of the business, when the transfer creating any security interest in the property acquired by the corporate debtor to the extent that security interest secures new value and was given at the time of or after the signing of security agreement that contains a description of such property as security interest and was used by the corporate debtor to acquire such property. And such transfer was registered with an information utility on or before 30 days after the corporate debtor received possession of such property. The proviso also mentions that any transfer made in pursuance of the order of a court shall not preclude such transfer to be deemed as giving preference by the corporate debtor. By way of explanation to section 43, the meaning of the words new value has been provided. It means the money or its worth in goods, services, or new credit or release by the transferee of property previously transferred to such transferee in a transaction that is neither void nor voidable by the liquidator or the RP under this code, including proceeds of such property, but does not include a financial debt or operational debt substituted for existing financial debt or operational debt. This was the meaning which has been explained by way of explanation. Now, preferential transactions and relevant time under subsection 4 shall be deemed to be given at a relevant time. What is the relevant time? If it is a related party transaction, then the period of 2 years. And if it is not a related party transaction, then it is the period of 1 year, 1 year or 2 years as the case may be, preceding the insolvency commencement date. Then what orders the adjudicating authority may pass that has been prescribed under section 44. That is, the Nclt may, when it receives an application from the RP or the liquidator, it can, by an order, require that property transferred in connection with the giving of the preference to be vested with the corporate debtor. It means whatever the property has been transferred within 1 year or within 2 years, as the case may be, related party or not related party, that will be vested again with the corporate debtor. Require any property to be so vested if it represents the application either of the proceeds of sale of property so transferred or of money so transferred. Release or discharge in whole or in part of any security interest created by the corporate debtor. Further, the adjudicating authority may require any person to pay such sums in respect of the benefits received by him from the corporate debtor and direct any guarantor whose financial debt or operational debts owed to any person were released or discharged by giving of the preference to be under such new or revived financial debt or operational debts to that person as the Nclt may deem appropriate. Direct for providing security or charge on any interest, any property for the discharge of any financial debt or operational debt under the order, and such security or charge to have the same priority as a security or charge released or discharged wholly or in part by giving the preference, and direct for providing the extent to which any person whose property is so vested in the corporate debtor or on whom financial debts or operational debts are imposed by the order are to be proved in the liquidation or corporate insolvency resolution process for financial debts or operational debts which arose from or were released or discharged wholly or in part by the giving of the preference. By way of proviso to section 44, it describes that the order under this section 44 shall not affect any interest in the property which was acquired from a person other than the corporate debtor. And if it has been acquired in good faith or value, to pay a sum to the liquidator or the resolution professional. By way of explanation 1 to this section 44, it describes that for the purpose of this section, it is clarified that where a person who has acquired an interest in property from another person other than the corporate debtor, or who has received a benefit from the preference or such another person to whom the corporate debtor gave the preference, had sufficient information of intimation or commencement of the CIRP of the corporate debtor or is a related party, it shall be presumed that the interest was acquired or the benefit was received otherwise than in good faith unless the contrary is shown. By way of explanation second, the person shall be deemed to have sufficient information or opportunity to avail such information if the public announcement regarding the CIRP was made. Now, section 45 deals with the undervalued transactions. The liquidator or the resolution professional, after examination of the transactions of the corporate debtor, if it determines that certain transactions were made during the relevant period under section 46, which are undervalued, then what recourse is available? He may make an application to the adjudicating authority to declare such transactions as void and reverse that transaction to the effect of such transaction just to nullify. A transaction shall be considered undervalued. So what are the circumstances under which the transaction shall be considered undervalued? Where the corporate debtor has made a gift to a person or enters into a transaction with a person which involves the transfer of one or more assets of the corporate debtor for a consideration the value of which is significantly less than the value of the consideration provided by the corporate debtor, and such transaction has not taken place in the ordinary course of business of the corporate debtor. Where an application for avoiding a transaction at undervalue, the liquidator or the resolution professional shall demonstrate that such transaction was made with any person within the period of 1 year preceding the insolvency commencement date, and if it is a related party within the period of 2 years preceding the insolvency commencement date, then the Nclt may require an independent expert to assess the evidence relating to the value of such transactions mentioned in that section. Section 47, application by creditor in cases of undervalued transactions. Where the undervalued transactions has taken place and the liquidator or the RP has not reported to the Nclt. In our earlier section, what we have seen that it is the duty of the liquidator or the RP, when he observes the undervalued transactions, he has to report to the Nclt. In this section 47, now it is the right of the creditor that if the liquidator or the RP is having the information of undervalued transaction and that liquidator or RP has not reported the transaction to the adjudicating authority, then the creditor may make an application to the Nclt to declare such transactions void and reverse their effect in accordance with this chapter. The Nclt, after examination of the application, if it is satisfied, it may treat as this transaction as undervalued transaction has occurred. Then liquidator or the resolution professional who has not reported such transaction, it shall pass such order restoring the position and will recommend to the IBBA to take the disciplinary action against such liquidator or the resolution professional. Order passed by the Nclt under section 45 subsection 1 may provide for the following: that require any property transferred as part of the transaction to be vested in the corporate debtor, release or discharge any security interest granted by the corporate debtor, require any person to pay such sums in respect of the benefits received by such person to the liquidator or the resolution professional as the Nclt may direct, or require the payment of such consideration for the transaction as may be determined by an independent expert. Now, section 49, subsection 1. This section 49 deals with the transactions relating to defrauding the creditors, where the corporate debtor has entered into an undervalued transactions and the adjudicating authority is satisfied that such transaction was deliberately entered into by such corporate debtor for keeping assets of the corporate debtor beyond the reach of any person who is actually entitled to make a claim, or in order to adversely affect the interest of such person in relation to the claim. The Nclt may make an order restoring the position as it existed before such transaction and protecting the interest of the persons who are victims of such transactions, provided that an order under this section shall not affect any interest in the property which was acquired from a person other than the corporate debtor and was acquired in good faith for value and without notice of the relevant circumstances, and shall not require a person who received a benefit from the transaction in the good faith for value and without notice of the relevant circumstances. Extortionate credit transactions. Section 50. Where the corporate debtor has been a party to an extortionate credit transactions involving the receipt of financial or operational debt during the period within 2 years preceding the insolvency commencement date, the liquidator or the RP may make an application for avoidance of such transaction to the Nclt if the terms of such transaction require exorbitant payments to be made by the corporate debtor. The IBBI may specify the circumstances in which a transaction which shall be covered under subsection 1. By way of explanation, it is clarified that any debt extended by any person providing financial services which is in compliance with any law for the time being in force in relation to such debt shall in no event be considered as an extortionate credit transaction. Now, the orders of the Nclt in respect of extortionate credit transaction, section 51, where the Nclt is satisfied that the terms of the credit transactions required exorbitant payments to be made by the corporate debtor, it shall by an order restore the position as it existed prior to such transaction and set aside the whole or part of the debt created on account of such extortionate credit transactions. Modify the terms of the transactions. Require any person who is or was a party to the transaction to repay any amount received by such person, or require any security interest that was created as part of the extortionate credit transactions to be relinquished in favor of the liquidator or the resolution professional, as the case may be. Section 52 deals with the secured creditor in liquidation proceedings. So it describes that secured creditor is having two options. Number one, that he may relinquish his security interest in the liquidation state and receive the proceeds from the sale of the assets by the liquidator. Number one option, he may relinquish the security interest. The second option is he may realize its security interest in the manner specified in this section. Let us take an example that a particular bank has given finance to a company to the tune of 50 lakhs by keeping the mortgage of its immovable property. The value of the mortgage property at the time of sanctioning of the loan was 75 lakhs. The outstanding amount is 50 lakhs. When the corporate debtor is not paying the dues to the bank and it was ordered by the adjudicating authority for liquidation, now that bank is already having the security interest of that mortgage of the property. Now that bank is having two options. Number one, by selling that mortgage property, that bank may realize its dues. Number one position, number one option. Okay. Let us suppose that outstanding is 50 lakhs, but due to application of the interest, the outstanding amount rose up to 90 lakhs. But the value of the mortgage property is still 75 lakhs. So what recourse is available with the secured creditor, that is the bank, that number one, he may relinquish its right for realization. So he may assign that mortgage property with the liquidator, and the liquidator will dispose of that property, and whatever the proceeds is realized by selling of that mortgage property, and the residual will be paid to the banker. So the secured creditor have both the option, either to relinquish or to realize. So the subsetting subsections of section 56 describes that before any security interest is realized by the secured creditor, the liquidator shall verify such security interest and permit the secured creditor to realize only such security interest, the existence of which may be proved either by record of such security interest maintained by an information utility or such other means as may be specified by the IBBI. And the secured creditor may enforce, realize, settle, compromise, or deal with the secured assets in accordance with such laws as applicable to the security interest being realized and to the security creditor, and apply the proceeds to recover the debts due to it. Subsection 5 provides that if in the course of realizing a secured assets, any secured creditor faces resistance from the corporate debtor or any person connected with therewith in taking possession of, selling, or otherwise disposing of the security, the secured creditor may make an application to the adjudicating authority, and the adjudicating authority will pass the necessary orders. As we have discussed, that when the security interest is realized by the secured creditor itself, and the realization is in excess of the debts, as we have given in the example that mortgage property value is 75 lakhs, outstanding amount is 50 lakhs. By selling of that mortgage property, the bank realized 75 lakhs. He may first liquidate its loan account, that is 50 lakhs. The residual amount remains with the bank is 25 lakhs. That 25 lakhs has to be given to the liquidator because it is a surplus amount. And if it is deficient, what we have discussed in another scenario, that outstanding amount after application of the interest reached from 50 to 90 lakhs, and the value of the property remains 75 lakhs, then the difference between 90 and 75, that is 15 lakhs, will be treated as an unsecured assets, and it has secured creditor have to inform the liquidator that when the proceeds are realized, out of that proceeds, wherever the in order of the priority, that is in the last priority, the unsecured creditor will be paid off if the assets are surplus. Where the proceeds of the realization of the secured assets are not adequate to repay the debts owed to the secured creditor, the unpaid debts of such secured creditor shall be paid by the liquidator in the manner as specified in section 53, subsection 1, subclass E. Now the distribution of the assets, how the assets after realization will be distributed among the creditors. Section 53 describes the order of the priority. The first priority goes with the insolvency resolution process cost and the liquidation cost paid in full. So whatever the amount is realized by selling of the assets, the first payment will be made towards this subclass A, that is insolvency resolution process cost and the liquidation cost. In second, there are 2-3 points which ranks equally among them. That is workman's dues for the period of 24 months preceding the liquidation commencement date, debts owed to the secured creditors, wages and unpaid dues of the employees 12 months preceding the liquidation date, financial debts owed to the unsecured creditors. So A, B, C, and D, it will be ranked on the equal footing. Then subclass E, the following dues shall rank equally between and among the following. Government dues, whether it be a central government or state government. Then debts owed to a secured creditor for an amount unpaid following the enforcement of the security interest, what we have discussed by way of an example. Any remaining debts and dues, and if any surplus remains, then the preference shareholders and later on the equity shareholders will be paid off from that distribution of the assets. Any contractual arrangements between the recipient under subsection 1 will equal ranking if disrupting the order of the priority under that subsection shall be disregarded by the liquidator. The fees payable to the liquidator shall be deducted proportionately from the proceeds payable to each class of the recipient, and the proceeds to the relevant recipient shall be distributed after such deduction. By way of explanation, it is hereby clarified that at each stage of distribution of the proceeds in respect of class of a recipient, the rank equally, each of the debts will be either be paid in full or will be paid in equal proportion within the same class of the recipient if the proceeds are insufficient to meet the debts in full. And the definition of the workman dues has been defined under Section 326 of the Companies Act 2013. Distribution of the corporate debtor, Section 54, where the assets of the corporate debtor have been completely liquidated, the liquidator shall make an application to the Nclt for dissolution of the corporate debtor. Nclt, after receiving the application from the liquidator, shall pass orders that the company may be dissolved accordingly. And that copy of the order shall within 7 days from the date of such order shall be forwarded to the authority within which the corporate debtor is registered, means the concerning jurisdiction of the registrar office. So friends, these are the forms which has been prescribed under the IBBA liquidation process regulations while the liquidation process is undergoing, that is form A, B, C, D, E, F, G. And the related regulations has also been mentioned in the regulation. Form A deals with the pro forma for reporting consultation with the stakeholders, how the public announcement will be made by the liquidator, that is in form B, how the operational creditors will make a claim, that is form C. Financial creditors have to make a claim under form D. Similarly, workmen or employees have to make claim in form E, and form F and form G like that. So let us have revise whatever we have discussed by way of MCQs. When the resolution professional can intimate the adjudicating authority the decision of the committee of creditors to liquidate the corporate debtor. Time पूछा है उन्होंने, at any time during the CIRP, at any time after the confirmation of the resolution plan, at any time during the CIRP, but before the confirmation of the resolution plan, and the fourth option is none of the above. Friends, let your answer come on this admin portal by writing question number 1 and correct option. So the answer is C, at any time during the CIRP, but before confirmation of the resolution plan. Next option, when a liquidation order has been passed, no suit or other legal proceedings shall be instituted or against the corporate debtor. However, this provision shall not apply to legal proceedings in relation to such transactions as may be notified by the central government in consultation with any. 4 options are given: financial service agency, financial service regulator, financial service provider, and financial services company. So the correct answer is the regulator, financial sector regulator, and references section 33, subsection 6. Next MCQ is, who have the authority to appoint a liquidator? Options are adjudicating authority, the board, IBBI, the committee of creditors, and the corporate debtor, who is having the authority. The authority based with the adjudicating authority, and the reference of this answer is section 34, subsection 7. Fourth option is the liquidator shall evaluate the assets and property of the corporate debtor in the manner as may be specified by the four options are given: adjudicating authority, the IBBI, COC, and the registered valuer. Liquidator shall evaluate the assets and property of the corporate debtor in the manner as may be specified by. Who will specify? So the answer is the board will specify, where it has been specified under the liquidation regulations. The last one is the liquidator shall receive or collect the claims of the creditors within a period of, fill up the blanks, from the date of commencement of the liquidation process, and the options given are the 10 days, 20 days, 30 days, and 40 days. So the answer is 10 days. Jay has asked two questions, but that what is the actionable claims? That I will give the exact definition by quoting the relevant provisions. And the another question that Jay has asked, that once the security interest surrendered, does the creditor have preference of payment from that asset when realized by the creditor? So what we have discussed, that the secured creditor is having two options. Number one, either to surrender the security interest with the liquidator, so that the liquidator will have the sole discretion to realize the assets and will pay in a phased manner and in order of priority, what has been mentioned in the provisions of the IBC. And the second option available with the secured creditor is not to surrender, but to realize the proceeds from by selling of the security interest at its own. As we have seen the example that a banker who has given a finance of 50 lakhs to a corporate debtor, and by way of keeping the mortgage of the immovable property, that at the time of sanction, the valuation of the mortgage property was 75 lakhs. So if the creditor, that secured creditor, taking option number one, that he will suo motu realize the security interest, he may realize, and if he has received the excess money, he has to first liquidate its own account, and whatever the remaining amount, if any remains, that has to be transferred to the liquidator. And if it is deficient, then he will be treated as an unsecured creditor, and at the priority of the order as provided in the IBC, that portion of the deficiency will be marked as an unsecured creditor. I think I have clarified the answer. Jay, kindly revert, and as regards the actionable claims, I will revert with the precise definition. Yes, one more candidate has asked for giving examples of undervalued transactions or extortionate transactions. Undervalued transactions, you may mean that, for example, a creditor within a period of 2 years or 1 year, if it is a related party or not related party, one person has supplied the goods. Say an example that operational creditor has supplied the goods to a corporate debtor. That value was only of 10 lakhs. Suppose operational creditor has supplied any type of goods and the invoice was raised as 10 lakhs and the corporate debtor has made the payment. Later on, it was revealed that the actual value of the goods supplied was much less than that was mentioned in the invoice. It may be 5 lakhs or 6 lakhs, but due to the having liaison with the corporate debtor, he has inflated the invoice and raised that amount up to 10 lakhs. Actual price may be 5 lakhs or 6 lakhs, but the invoice was made with the 10 lakhs. This is called the undervalued transactions or overvalued transactions. And the extortionate credit transactions means when a corporate debtor is giving favor with any of the persons, that is called the extortionate credit transactions. And that extortionate credit transactions has to be decided within 1 year or 2 years, as the case may be related party or not related party. So if the liquidator or the RP comes to this knowledge of this undervalued transactions or extortionate transactions, he may apply to the adjudicating authority for reversal of the transactions. Okay. And if the liquidator or the RP is not prudent in deciding or referring the matter to the Nclt, and if any creditor comes to the knowledge of this type of examples, then he may suo moto make a reference to the Nclt, and if Nclt examines that the reference made by such creditor is correct, then the Nclt may make a representation to the Nclt, to the IBBI for taking disciplinary action against that liquidator or the RP. So I think I have narrated the correct answer of these questions, and as regards the actionable claim, I will revert just after this short break. So Nisargi, we will have a short break of 10 minutes. Right now it is Yes, please. PPT is being shown. Just a minute. Yes, friends, welcome again. The last in last MCQ, one person has raised the query that the liquidator shall receive or collect the claims of creditors within a period of, and four options were given: 10, 20, 30, and 40. And I have opined the answer as 10 days. So one has asked that it may be C, 30 days. Let me clarify that Section 38(1). Section 38(1) of the IBC mentions that the liquidator shall receive or collect the claims of creditors within a period of 30 days from the date of commencement of the liquidation process. That's why the period is the 30 days and not the 10 days. And one more question that was asked about the actionable claims. So in simple terms, what is the actionable claims? I may define that actually the exact wording has been defined under the Transfer of Property Act under Section 3. Under Section 3 of the Transfer of Property Act, which I may read out that paragraph, that actionable claim means a claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation or pledge of the property, or to any beneficial interest in movable property not in possession, either actual or constructive, of the claimant, which the civil courts recognize as affording grounds for relief, whether such debt or beneficial interest rented out to any person, and the monthly rent or say yearly rent is about 10 lakhs rupees. Okay. And the corporate debtor has not realized that rent. So this is termed as an actionable claim. The claim which can be exercised by the corporate debtor, it is called the actionable claim. So I think I have clarified all your answers. So now let us move to the next important aspect, that is the prepackaged insolvency resolution process. In short, we may call it as a Ppirp. So Chapter 3 of the IBC, which was inserted by way of an amendment in the IBC code. And why this Chapter 3 was inserted, that it takes care of the Ppirp for the MSME companies. It is solely for the MSME companies. So Chapter 3A, right from Section 54A to 54P, deals with the Ppirp process. And there is one rule and one regulation that has been prescribed under the IBC: Insolvency and Bankruptcy Prepackaged Insolvency Resolution Process Rules 2021. And another one is the regulation that is titled as IBBI Prepackaged Insolvency Resolution Process Regulations 2021. Now, let us have a viewpoint on the CIRP and Ppirp. As we have discussed that what is CIRP, initiation of the CIRP under Section 7 by the financial creditor, then 8 and 9 relates to the operational creditors, and finally Section 10 relates to the initiation of CIRP by the corporate debtor itself. Now, what Ppirp means for? So by way of introduction, this slides depict that this IBC code, IBC 2016, provides that insolvency resolution of persons in financial distress. The code provides two broad categories, that is the CIRP and Ppirp. And this chapter 3 was inserted in the IBC by way of an ordinance amendment in 2021 with effect from 4th April 21. And this PPIRP is available for resolution of stress of the corporate MSMEs and is available as an alternate option and should the stakeholders like to use it. Now, section 54A to 54P deals with this chapter 3A. 54A deals with corporate debtors who are eligible for the PPIRP. And when this PPIRP is initiated, what are the duties of the insolvency professional? I am using the word insolvency professional, not the resolution professional, which have been mentioned in section 54B. So section 54B, duties of the IP before initiation of prepackaged insolvency process. Then 54C, then application to the or initiation of PPIRP, and what is the time limit that has been prescribed under section 54D. Then similarly, the declaration of the moratorium, public announcement, what are the powers and duties of resolution professional, and list of the claims, preliminary information memorandum. All things, as we have discussed in the CIRP, are also applicable under the PPIRP process. Then management of the affairs, committee of creditors, vesting of management of corporate debtors, right from this 54S to 54P relates to this. And there are appeal matters and termination of the PPIRP matter that we will be discussing in the following slides. So one question may come in our mind that what's the difference between the CERP and this PPIRP, prepackaged insolvency resolution process. So let us have a discussion on this difference. What are the differences points before discussing in detail with the provisions of the PPIRP. So the CIRP is applicable for all corporate debtors, including the MSME. So CIRP is having no distinction between the MSME or non-MSME companies, but in case of PPIRP, it is available only to the MSME companies. Okay. CIRP, there is no alternate option is provided, but in case of PPIRP, the alternate option is given under the law, under the IBC, that is the company which is classified under the MSME may opt for the PPIRP or CIRP. Both the options are available. CIRP is a non-voluntary in nature. PPIRP is voluntary in nature. It means the company have the option either to take option 1 PPIRP or take another option of CIRP. CIRP is totally a formal procedure. In case of PPIRP, it is having a blend of both the options. To some extent, it is informal, and to some extent, it is formal. In CIRP, the creditors are in possession of the management of the affairs. But in case the PPIRP, it is a hybrid model. In the first phase, the creditors are in possession, and in the second phase, the creditors are in control. CIRP is a fully public process. Fully public process. PPIRP, it is neither fully private nor fully public process. It is a mixture of both this. Means it is having the advantages of both the options. CIRP is, in case of CIRP, it is more rigorous than PPIRP. PPIRP has the features which make the CIRP sacrosanct. See, in CIRP, there is no concept of best resolution plan. Best resolution plan means the plan which have been prepared by the corporate debtor. In case of CIRP, the resolution plan is prepared by the resolution applicant. But in case of PPIRP, the best resolution plan is initially prepared by the corporate debtor itself. Then it has to be produced before the COC. In CIRP, it has a comprehensive role of the adjudicating authority and so of the IPs. In case of PPIRP, it entails a limited role of the courts and IPs. Now, let us consider some important definitions which have been prescribed under this chapter 3. Base resolution plan. Base resolution plan, section 5, subsection 2A. It means a plan which has been provided by the corporate debtor. In case of CERP, what we have discussed, that resolution plan is prepared by the resolution applicant. He is an outsider. Section 5, subsection 23B. One question Jay Srivastava asked, what is the public process? Public process, when we are discussing about this difference between the CIRP and PPIRP, yes. Public process means it is publicly announced that the CIRP has been initiated either in section 7 or in section 9 by the operational creditor or in section 10 by the corporate debtor itself. When the CIRP application is admitted by the adjudicating authority, a public announcement is made by the concerning IRP that the concerning corporate debtor is undergoing the CIRP. It means publicly the adjudicating authority has announced through the IRP that particular company is going under CIRP process. But in case of PPIRP, it is not publicly announced initially. So later on we will discuss about that, whether how it is informal to some extent and how it is formal later on. So again, come to the definition part, section 5, subsection 23. What is the prepackaged insolvency commencement date? The date when the admission of the application is initiated under the PPIRP by the Nclt. Then what is the PPIRP cost? The amount of interim finance and the cost incurred in raising such finance, fees payable to any person acting as the resolution professional and any expenses incurred by him, any cost incurred by the RP in running the business, any cost incurred at the expense of the government to facilitate the PPIRP, and any other cost as may be specified. These are the some of the important definitions which has been prescribed under section 5. Then what is the period? Period means beginning from the date of prepackaged insolvency commencement date and ending on the date on which an order is given by the Nclt under section 54L subsection 1, similarly 54N subsection 1 and 54O subsection 2 as the case may be, which is passed by the Nclt. So in a nutshell, what are the stages of the PPIRP? We may divide the stages in the 5 subsections. That is the pre-initiation stage. Then application for initiation, post-initiation, approval of the resolution plan, and finally the closure of the PPIRP. What is the eligibility for the PPIRP? The first condition for the eligibility of the PPIRP is that the corporate debtor should have been classified as MSME as provided under section 7 subsection 1 of MSME Act 2006. If a company do not comes under the definition of the MSME as provided under section 7 subsection 1 of MSME Act, that company is not eligible for undergoing PPIRP. So first condition, classification under MSME is must. Then if that company has committed a default of at least 10 lakhs rupees, is eligible to submit resolution plan under section 29A, which we have already discussed. has not undergone a PPIRP or CIRP during the 3 years preceding the initiation date, is not undergoing a CIRP, is not required to be liquidated by an order under Section 33 of the Code. So these are 5-6 conditions which are to be fulfilled before initiation of this PPIRP. Now someone may ask that what describes the Section 7, Subsection 1 of the MSME Act 2006. The definition of this MSME has recently been revised with effect from 1st of July 2020. Friends, as you may remember that right from February or March 2020, there was a pandemic situation began, and the government announced some financial packages or relief measures. And in that category, the MSME definition was revised. So in case of micro, small, and medium, the classification of investment in plant and machinery and the annual turnover, 2 criteria has been defined. In case of micro, the investment in plant and machinery should not exceed 1 crore. In case of a small, should not exceed 10 crores. And in case of medium, it should not exceed 50 crores. As regards the annual turnover is concerned, in case of micro, it should not be more than 5 crores. In a small, it should not be 50 crores. And in case of medium, it should not be 250 crores. That is the definition which was revised with effect from 1st of July 2020 relating to the MSME. Now, in the previous slides, we have discussed about the 5 stages of the PPIRP. The first stage we will discuss now, that it is the pre-initiation phase of the PPIRP. Pre-initiation phase envisages a hybrid process where the pre-initiation phase is largely informal and post-initiation stage is the formal. Yes, Jay has asked that default amount under 1 crore under CIRP, but under PPIRP it is 10 lakhs, so that it means the limit is reduced. Yes, that has been given under the by way of notification, and the default amount under the CIRP is 1 lakh rupees, and it can be extended that minimum amount up to the 1 crore rupees by way of notification. Under the CIRP. Under CIRP, the minimum amount of default is 1 lakh rupees. It was increased during the pandemic period only up to 1 crore rupees by way of notification. But in Section 3 and Section 4, if you read out that section, that default minimum amount of default is 1 lakh. But in case of MSME, by way of notification, the government has defined this minimum default as rupees 10 lakhs. The informality at pre-initiation stage offers flexibility for the corporate debtor and its creditors to swiftly explore and negotiate the best way to resolve stress in the business, while the initiation stage drives value maximization and establishes the resolution plan with the statutory protection. Now, pre-initiation stage, what activities are required to be done, that is contained in Section 54A, Subsection 2, Subclause E. For seeking of the approval of the creditors under this section, the applicant shall convene a meeting of the unrelated financial creditors who are not related parties to the corporate debtor. So let us take an example that ABC Limited comes under the definition of the MSME, and it has defaulted in repaying the dues to the financial creditors, and this ABC Limited wants solution to come out with this financial stress. So what this ABC Limited will do, that it will convene a meeting of financial creditors. Which financial creditors which are unrelated. We have termed as a unrelated financial creditor, that is the UFCs. Where the corporate debtor has no financial debt or where all the financial creditors are related parties, the concerning company will convene the meeting of unrelated operational creditors, that I have abbreviated as UOC, unrelated operational creditors, and the UOCs shall perform the same duties and functions as the UFCs. So what we are discussing, it is the pre-initiation stage. Pre-initiation stage, first phase, that company has defaulted, that company has been classified as MSME. That company will first convene a meeting of the financial creditors. Which financial creditors? Which are not related parties. For convening a meeting of the unrelated financial creditor, the applicant shall serve a notice to all the UFCs at least 5 days before. And the notice of the meeting shall indicate the date, time, venue, and the specific agenda for discussion. What happens in section 7, that the financial creditor, when that is not receiving the dues from the corporate debtor, initiates or files the application before the adjudicating authority. In the case of PPIRP, the MSME company who has made default in making payment to the lenders will convene a meeting of the financial creditors. So see the difference. That is the pre-initiation stage. Now the applicant shall enclose a list of the creditors and the amount due to each of them. So what we have taken the example that ABC company is calling a meeting of the financial creditors, and notice has been served to all the financial creditors, enclosing in that notice the list of all the creditors and amount due against each of the creditors. What is the purpose? For seeking an approval for appointment of an IP as RP. Now the words which have been mentioned in the insolvency code is the IP. In case of section 7, the financial creditor has proposed the name of insolvency professional who will act as an IRP. Here the words have been used as insolvency professional who will later on will act as RP, but not right now as an RP, but he will act as an insolvency professional. So who is the appointing authority in case of IP? Here the appointing authority is the financial creditors, not the adjudicating authority. Adjudicating authority will appoint later on when the system is formalized, but it is presently initiation stage, it is at the informal stage. So which IP has to be selected or appointed? Who is eligible to be a RP later on when the system gets formalized. So later on in the meeting, the creditors having at least 10% of the value of the debt shall propose the name of the IP eligible under the regulation for appointment as RP. And insolvency professional is eligible to be appointed as RP if and all its partners and directors of the insolvency professional entity IPE, of which he is a partner or director, are independent of the corporate debtor. A person is considered independent if he meets the requirement specified under Regulation 7. So these are the independence criteria which has been mentioned, that a person who can be appointed as an independent director, it means he is having the independence. The UFCs representing not less than 66% in value of the debt due to such creditor shall approve the appointment of the RP and the terms of the appointment in form number P3. The terms of appointment shall include the fee payable for performing duties, fee payable to him and the expenses, and fee payable to him and the expenses incurred by him in case the management of the CD is vested with him under section 54G. We are discussing about the pre-initiation stage. The majority of the directors or partners of the corporate debtor shall make a declaration that corporate debtor shall file an application for initiation within a definite time period not exceeding 90 days. So from the date of convening a meeting to the date of expiry of this 90 days, it is called the pre-initiation date. That the PPIRP is not being initiated to defraud any person and approved by the creditors to be appointed as the RP. Now the members of the corporate debtor shall pass a special resolution, or at least 3/4 of the total number of partners in case it is a LLP shall pass a resolution approving the filing of an application for initiating PPIRP as required under section 54A subsection 2 subclass G. The CD shall prepare a best resolution plan. In case of CIRP, the resolution plan is always prepared based on the information memorandum supplied by the IRP to the resolution applicant. But in case of PPIRP, the best resolution plan is prepared by the corporate debtor. And along with the notice for convening the meeting seeking approval for filing of an application for initiating PPIRP, the applicant shall enclose a list of creditors, declaration, resolution of the members, and the base resolution plan. So base resolution plan is always prepared by the corporate debtor. In the meeting of the UFC, creditors representing not less than 66% in value of the debt due to such creditors shall approve filing of the application for initiation of PPIRP of the CD under section 54A subclass 3 in a prescribed form, that is form P4. The IP from the list of the creditors in form P2 identify 3 IPs to act as authorized representative of the concerning creditors and obtain their consent in a prescribed form, that is P5. Seek choice of the creditors in the class, select the IPs who is the choice of the highest number of creditors in the class to act as authorized representative, and inform the name of the IPs along with the consent in the prescribed form, that is P5. Then IP shall prepare a report in form P8 confirming if the CD is eligible for PPIRP and the BRP confirms the requirements. Up to this stage, we have discussed about the pre-initiation stage. Now the application for the initiation, only a corporate applicant can file an application for initiation of the PPIRP. Applicant shall file the application in the prescribed form, that is form 1, that is electronically with the adjudicating authority. Application shall be accompanied with the following documents: record of default, consent of the IP, approval, consent of the IP proposed, declaration by directors, members resolution, declaration by CD, report of the RP, and audited financial statements of the last 2 financial years. Then audited financial statements of the last 2 financial years, provisional financial statements, latest and updated Udyam registration certificate. The Udyam registration certificate is applicable in the case of MSME classified companies only. Affidavit stating that the CD is eligible under section 29A. Statement of affairs made up to the date not earlier than 14 days. Statement giving names and address of the members or partners with details of their respective shareholding. Proof that the application fee of rupees 15,000 has been paid. Proof that a copy of the application has been served to the IBBI, and document that record the authority of the applicant to make the application where the applicant is a member or partner of the corporate debtor. Now the application for initiation under subclass 4, the applicant shall serve a copy of the application to the IBBI before filing it with the adjudicating authority as The procedure is similar as we have seen in the CIRP case. And within 14 days of the receipt of the application, the adjudicating authority shall admit the application if it is complete or reject the application if it is incomplete. Then PPIRP shall commence on the date of admission of the application. The adjudicating authority shall on the PPIRP commencement date, along with the order of the admission, declare a moratorium. The duties of the IP shall cease if the application is either not filed within the time specified in declaration or is admitted by the adjudicating authority. Again, the process is required to be completed within a time frame of 120 days from the PPIRP commencement date. In the CIRP, the initial time period prescribed was 180 days. In this case, it is the time period prescribed is 120 days. Now, post-initiation phase, during the PPIRP, the management of the affairs of the CD shall continue to vest in the board of directors. What we have discussed in the CIRP, that management of the affairs of the corporate directors vest with the IRP. But in case of PPIRP, all the affairs of the management of the corporate directors shall vest with the board of directors or its partners if it is a LLP. The board of directors or the partners shall make every endeavor to protect and preserve the value of the property of the CD and manage its operation as a going concern. Promoters, members, personnel, and the partners of the CD shall exercise and discharge their contractual and statutory rights and obligations in relation to the CD. The CD shall, within 2 days of the PPIRP commencement date, submit to the RP, updated as on the date, the list of the claims in the prescribed form, preliminary information memorandum containing information relevant to formulation of resolution plan, that is called the PIM also. And if any person sustains any loss or damage as a consequence of omission of any material information or inclusion of any misleading information in the list of claims as mentioned in the PIM, every person who is a promoter or director or partner of the CD at the time of submission of that PIM or has authorized the submission of the list of the claims of the PIM shall be liable to pay the compensation. CD shall submit the BRP, that is the best resolution plan to the RP within 2 days of the PPIRP commencement date. Now the best resolution plan which was prepared by the corporate debtor will be submitted before the RP within 2 days of the commencement date of the PPIRP. Yes, of course, the corporate debtor may revise the BRP and review it and peruse it before the RP. The RP shall make a public announcement in a prescribed form within 2 days of the commencement, and RP shall thereafter exercise the powers and carry out the duties as required under Section 54F. If the BRP does not impair claims owed to the operational creditors, the COC may approve it for submission to the adjudicating authority. And if the COC does not approve the BRP, that is the best resolution plan, or the best resolution plan impair the claims of the operational creditors, the RP shall invite prospective resolution applicants to submit resolution plans to compete with the BRP. He shall publish brief particulars of the invitation of the resolution in plans in form P 11, not later than 21 days from the PPIRP commencement date in accordance with the Regulation 43. Then invitation for resolution plan shall detail each step in the process and the manner and purposes of interaction between the RP and the resolution applicant along with the corresponding timelines. It shall include the basis for evaluation, basis for considering a resolution plan, tick size, and the manner of improving a resolution plan. Resolution plans received in response to the invitation and complying with the requirement of the code and regulation shall be evaluated on the basis for evaluation. The resolution plan which gets the highest score shall be selected as best alternate plan, that is short as BAP, for competition with the BRP. COC may consider BRP for its approval if no resolution plan is received, COC may consider the BAP for approval if it is significantly better than the best resolution plan. And if the BAP is not significantly better than the BRP, the RP shall disclose the scores of the BAP and BRP to submitters of these plans and invite them to improve their plans in accordance with the Regulation 48. The process of improvement shall continue till either of the submitters fail to use the option within the specified time. The resolution plan having higher score or completion of process of improvement shall be considered by the COC for approval. If the COC does not approve it, the process terminates. Now the closure of the PPIRP, that is the final stage. The PPIRP closes in the following circumstances: on approval of either the best resolution plan or best alternate plan by the adjudicating authority, on expiry of the 90 days if the resolution plan is submitted to the approval before the adjudicating authority, rejection of the resolution plan by the adjudicating authority, on approval by the adjudicating authority of application filed by the RP for termination of the PPIRP, where the CBOC approves termination with a vote of not less than 66% of the voting shares. Then on conversion of the CIRP based on an application filed by the RP, when the COC approves so with 66% of the voting share and the CD is eligible for CIRP. An order for termination in case where no resolution plan is approved by the COC or the resolution plan approved by the COC does not result in change in the management, where the adjudicating authority has vested the management of the CD with the RP under section 54G. Now, what are the responsibilities of the corporate debtor and the applicant? The responsibilities of the corporate debtor is to identify the creditors, financial creditors and the operational creditors, prepare a list in the prescribed form, that is P2, convene a meeting, make a declaration of the majority of the directors, pass a special resolution from the members in the general meeting, and prepare a best resolution plan, convene the meeting of the creditors and seek approval for filing of the application, and prepare a declaration regarding the avoidance of transactions. Prepare the audited financial statements, filing of the application for initiation of PPIRP, prepare preliminary information memorandum, that is PIM, prepare a list of claims, submit preliminary information list of creditors and BRP to the RP, manage the affairs of the CD as a going concern, protect and preserve the value of the property, and participate in the process to improve the best resolution plan. Now, what are the responsibilities of the resolution professional? To give consent that yes, I may give the consent to act as an RP if eligible under the regulation. Ascertain the classes of the creditors, that who are the financial creditors, who are the operational creditors, collect the information relating to the assets and liabilities of the CD, prepare and submit the report confirming that CD is eligible for the PPIRP and the BIRP conforms to the requirement. Make public announcements, appoint registered valuers, and confirm the list of the claims and update it. Constitution of the COC, convening the meeting, submit the information memorandum before the COC, invite prospective resolution applicants, conduct the process of improvement of the resolution plan, present to the COC for its evaluation compliant resolution plan, submit the resolution plan for approval by the COC, and subsequently to the adjudicating authority, and submit the application for termination of the PPIRP when approved by the COC. These are the responsibilities of the resolution plan. It further elaborates that to form an opinion and make determination about the avoidance transactions, attend the meeting of the members of the board and committee members, monitoring the management of the affairs of the CD, report to the CC in COC in the event of breach of any obligation of the board of directors or partners, and manage the affairs of the corporate debtor when the adjudicating authority approves application vesting management of the CD. Now we have discussed the responsibilities of the corporate debtor as well as the insolvency, this resolution professional. Now responsibility on the part of the debtors are to approve the name of the IP, to act as RP, to select the IP as authorized representative, approve filing of the application for initiation of PPIRP, assist the RP to finalize the list of claims, consider the BIRP, and allow the opportunity for revision, approve eligibility criteria for prospective resolution applicants, and approve the basis for evaluation. Significantly better plan, approve tick size, specify parameters for improvement of process, evaluate the resolution plans, resolve to vest the management of the corporate debtor with the RP, and may resolve to initiate the corporate insolvency resolution process in respect of the CD. Now, whatever we have discussed so far, that can be presented by way of a flow chart of the PPIRP. The flow chart depicts that first there should be a mutual understanding. List of creditors has to be finalized, then identification of the IP to act as RP, then declaration by majority of the directors. Shareholders' resolution has to be passed by the corporate debtor. Consent of the majority of the unrelated financial creditors has to be obtained. Report preparation by the RP. Then application has to be filed before the adjudicating authority. Updated list of claims. Preliminary information memorandum has to be prepared by, that is the PIM. Then base resolution plan is prepared by the corporate debtor. Then adjudicating authority may approve or disapprove. RP may constitute the COC after the adjudicating authority has approved or admission of the PPIRP. Then the CD submits the BRP matlab best resolution plan. Then basis of evaluation is disclosed and best alternate plan is selected. Best alternate plan is not significantly better than best resolution plan, then BRP will prevail. COC approves or declines the plan. If declined by the COC, PPIRP is closed without resolution. If COC approves the plan, then it has to be submitted to the adjudicating authority for approval. If no plan is received, the COC may approve the BRP. BRP so approved by the COC is submitted to the adjudicating authority. Adjudicating authority approves and the PPIRP is closed. If not approved, the PPIRP closes without the resolution. This was all about the flow chart of the PPIRP. So a model timetable has been suggested by the IBBI in its regulation. That is commencement of the PPIRP. E is marked as today, that is one day. Then submission of claims, T+2. Then public announcement. Then appointment of the registered valuers. Then constitution of the COC within T+7 days, T+14 days. First meeting of the COC. Submission of IM. Publication of the invitation. It is a suggestive model plan. Time may vary. Then evaluation T+89. Similarly, if we see out that the last point is the T+120th day, and in PPIRP, this whole of the process has to be completed within a period of 120 days. These are the forms under the prepackaged insolvency resolution process, that is form 1 to 10. Then 11 to 13. So let us revise what we have discussed about the PPIRP concept. Friends, you may give your option on the admin portal. An application for initiation of PPIRP may be made in respect of corporate debtor classified as a small company, startup company, MSME company, or private limited company. So PPIRP is concerned only with the companies who are enjoying the status of MSME. The majority of the directors of the corporate debtor have to make a declaration stating that corporate debtor shall file an application for initiation of PPIRP within a definite time period. And the options given are not exceeding 30 days, 60 days, 90 days, and 120 days. The correct option is the 90 days. Reference is also mentioned, section 54A, subsection 2, subclass F and I. Application for initiating PPIRP may be made in respect of a corporate debtor who submits a default with the condition that members of the corporate debtors have passed. Fill up the blanks. Approving the filing of an application for initiating PPIRP. And 4 options have been provided. An ordinary resolution, a special resolution, a board resolution by circulation. Which of the option is correct? So what we have discussed is the correct answer is the special resolution. The corporate debtor shall obtain an approval from its financial creditors representing, fill up the blanks, in value of the financial debt due to such creditors for the filing of an application for initiating PPIRP. The options given are not less than 51%, 66%, 75%, and 90%. So the correct option is 66%. Section is 54A, subsection 3. Who shall prepare the best resolution plan in the matter of PPIRP? 4 options have been provided: the financial creditor, resolution professional, resolution applicant, or the corporate debtor. The correct answer is the corporate debtor. So friends, after having discussed with the provisions relating to the liquidation and this PPIRP, now we would like to discuss on the fast track CIRP. The provisions relating to the fast track CIRP are contained under section 55 to 59. And the relevant regulation is the fast track insolvency resolution process for the corporate persons, regulation 2017. So in your syllabus also, the entire IBC is not provided under the syllabus. It is only up to the section 59. Fast track corporate insolvency resolution process, in short, FTCIRP. CIRP, PPIRP, and FTCIRP. 3 classes of the CIRP which we have discussed. So section 55. A CIRP carried out in accordance with Chapter 4 shall be called as FTCIRP. An application for FTCIRP may be made in respect of the following corporate debtors, namely: number 1, corporate debtor with assets and income below a level as may be specified by the central government. Corporate debtor with such class of creditors or amount of debt as may be notified by the central government, or such other category of the corporate persons as may be notified by the central government. So CIRP is for all category, PPIRP is only for the MSME classified companies, and for FTCIRP is only for the 3 categories which are having a limit, threshold limit as prescribed by the central government, that is assets or income below a threshold limit. Such class of or creditors as prescribed by the central government or any other class. So let us see what has been prescribed under this notification. That this notification of 14th June 2017, the Government of India has notified that an application for FTCIRP may be made in respect of the following corporate debtors, namely. What are they? That is the small company, startup company, and unlisted company with total assets not exceeding rupees 1 crore. Now, what is the meaning of this startup company? The meaning of a startup company has been defined under notification, Gazette notification dated 23rd May 2017. An entity shall be considered as a startup if it is incorporated as a private limited or registered as a partnership firm or LLP, and up to 7 years from the date of incorporation or registration. However, in case of a startup, the biotechnology sector, the period shall be up to 10 years from the date of its incorporation or registration, and if its turnover for any financial year since incorporation has not exceeded 25 crore rupees, and its working capital towards innovation, development, improvement of products or processes or services, or if it is a scalable business model with a high potential of employment generation or wealth creation, provided that such entity formed by splitting up or reconstruction of business already in existence shall not be considered as a startup. So the definition of the startup has been given by way of notification, Gazette notification of May 2017. Now come to the second category of applicability of this FTCIRP, the small company. The small company is defined under Section 2, Subsection 85 of the Companies Act. It means a company other than a public company. It means a small company is always a private limited company, paid up share capital of which does not exceed 50 lakhs rupees, or such a higher amount as may be prescribed, which shall not be more than 10 crore rupees, and turnover in immediately preceding financial year does not exceed 2 crore rupees, or such higher amount as may be prescribed, which shall not be more than 100 crore rupees, provided that nothing in this clause shall apply to a holding company or a subsidiary company, a company registered under Section 8, or a company or body corporate governed by any special act. So there is the definition of the small company, which is prescribed under the provisions of the Companies Act 2013. Now, what is the time period for completion of the fast track CIRP? In CIRP, the time period, the normal time period prescribed is 180 days, and extension may be granted up to 90 days. In case of fast track CIRP, the period prescribed is 90 days, 90. The RP shall file an application to the Nclt to extend the period of FTCIRP beyond 90 days if instructed to do so by way of resolution passed at the meeting of the COC and supported by a vote of, please pay attention, by a vote of 75% of the voting chair. Here, the percentage mentioned is 75%, not 66%. On receipt of application, if the Nclt is satisfied that the subject matter is such that fast track CIRP cannot be completed within 90 days, it may extend only for one time, but not exceeding 45 days. Manner of FTCIRP, it may be filed by the creditor or the corporate debtor, as the case may be, along with the proof of existence of default. and any such other information as may be specified by the IBBI. To this fast track CIRP, all the provisions relating to the chapter 2, which pertains to the provisions relating to CIRP, are also applicable to chapter 4. So there is nothing changes in that. Whatever we have discussed in our previous session while discussing the chapter 2 of the CIRP are also applicable on this section. So these are the various forms which are to be which are prescribed under this fast track CIRP. So let us revise this what we have discussed about the fast track CIRP provision. That what is the time period for completion of fast track CIRP process? Within a period of 45 days, within a period of 90 days, 180 days, or 270 days. So 180 days is for the CIRP, 90 days or 45 days. Initially it is 90 days and later on it is 45 days if it is granted extension. So correct answer is the B, within a period of 90 days. The adjudicating authority may extend the period of fast track corporate insolvency resolution process beyond 90 days if instructed to do so by way of a resolution passed at a meeting of the Committee of Creditors and supported by a vote of 51%, 66%, 75%, and 90%. Most of the students may confuse about this 66%. But in case of fast track, it is the 75% of the voting share. And the answer is supported by section 56, subsection 2. The adjudicating authority may extend the duration of fast track CIRP beyond the period of 90 days by such further period as it thinks fit, but not exceeding. The options given are 15 days, 30 days, 45 days, 60 days. So the correct answer is 45 days. The extension by the CIRP adjudicating authority. Extension by the adjudicating authority may be granted in case of fast track CIRP for the 4 options are given. No extension may be granted, not more than once, not more than 2 times, or not more than 3 times. So the correct answer is not more than once. So the last section is the section 59, that is the voluntary liquidation process. And the related regulation is the voluntary liquidation process regulation 2007. When the enactment of the IBC, with the enactment of the IBC, the provisions of voluntary winding up and winding up on the grounds of inability to pay debts. There are 2 words, voluntary winding up and inability to pay debts have been removed from the Companies Act 2013. The proceedings relating to these are now under the ambit of the IBC. Liquidation in case of default in payment or repayment of any debt is not directly possible. For such entities, the emphasis is on the resolution. And if the resolution process does not result in approved plan, the liquidation process order is passed by the adjudicating authority under section 33, which we have already discussed. But in case of no default, a corporate person can initiate voluntary liquidation under section 59 of the IBC directly. A corporate person who intends to liquidate itself voluntarily and has not committed any default may initiate voluntary liquidation proceedings under this chapter. And the related regulations is IBBI Voluntary Liquidation Process 2017. What is the procedure? That the voluntary liquidation proceedings of a corporate person registered as a company shall meet the following condition. Number 1, declaration from majority of the directors of the company verified by an affidavit that they have made a full inquiry into the affairs of the company and they have formed an opinion that either the company has no debt, or if the company is having the debt, it have the ability to pay the entire debt, and the company is not going for liquidation to defraud any person. That declaration has to be accompanied with the following document, that is audited financial statements and record of business operations of the company for the previous 2 years or for the period since its incorporation, whichever is later. A report of the valuation of the assets of the company, if any, prepared by the registered valuer. And within 4 weeks of such declaration, there shall be a special resolution by the members of the company in the general meeting requiring the company to be liquidated voluntarily and appointing an insolvency professional to act as liquidator. A resolution of the members of the company in general meeting requiring the company to be liquidated voluntarily as a result of expiry of the period of its duration, if any, fixed by articles, or occurrence of any event in respect of which the articles provide for declaration for the company to be dissolved, as the case may be, and appointing an insolvency professional to act as liquidator, provided that the company owes any debt to any person and creditors representing 2/3 in the value of the debt of the company shall approve the resolution plan within 7 days of such resolution. Company shall notify the ROC and the IBBI about the resolution to liquidate the company within 7 days of such resolution. And subject to the approval of the creditors, the voluntary liquidation proceedings in respect of the company shall be deemed to have commenced from the date of passing of that resolution. Then provisions of section 35 to section 53 relating to chapter 3 and chapter 7 shall apply to voluntary liquidation proceedings. Where the affairs of the corporate persons have been completely wound up and its assets completely liquidated, the liquidator shall make an application to the adjudicating authority for dissolution of such corporate persons. The adjudicating authority shall, on an application filed by the liquidator, pass an order that the corporate debtor shall be dissolved from that order, and the corporate debtor shall be dissolved accordingly. Copy of that order within 14 days of such order shall be forwarded to the concerning authority where the corporate person is registered. These are the forms which have been prescribed under the IBBI Voluntary Liquidation Process regulations. So let us review about the voluntary liquidation through some of them MCQ. The conditions and procedural requirements of conducting voluntary liquidation of corporate person shall meet the criteria as specified by 4 options are given: the adjudicating authority, the board, the central government, and the Supreme Court. So which of the option is correct? The criteria has been prescribed by the IBBI. Under voluntary liquidation of corporate person, majority of the directors have to give a declaration as per section 59A and fill up the blanks of such declaration. A special resolution of the members of the company in a general meeting requiring the company to be liquidated voluntarily and appointing an insolvency professional to act as the liquidator. 4 options are given: within 2 weeks, 3 weeks, 4 weeks, or 5 weeks. So what we have discussed, it is the 4 weeks. In voluntary liquidation, the company shall notify the registrar of companies and the board about the resolution under section 59(3) to liquidate the company, fill up the blanks, of such resolution or subsequent approval by the creditors as the case may be. 4 options are given: within 3 days, 7 days, 14 days. And option D may be read as within 20 days, 28 days. So the correct option is within 7 days. So today we have discussed about the liquidation process, the Ppirp process, the voluntary liquidation, and the fast track method. So by this we have discussed section 1 to section 59, which is prescribed in your syllabus. And if you have any query, whatever we have discussed, you may write on this admin portal by way of question, and certainly we will answer. And we will also display some MCQs, 15-20 MCQs covering all the relevant portion, right from the CIRP and to liquidation, Ppirp and fast track, just to revive whatever we have discussed. And we shall also share this PPTs with you, whatever we have discussed in 2-3 days. And the same are also available on the ICAI YouTube channel. With these words, I extend my thanks to all the friends and students who have patiently listened and responded on the admin portal to my queries. And thanks to all. And Nisargji, with these words, I am concluding my session.